Does the next of kin get someone's money when they die? When you either put your money in the bank or M-Pesa, maybe invest or buy an asset, has it ever bothered you on who will access it or take it in the event you're not there? Are you aware that even if your account is loaded, your spouse or child will be broke and struggling for close to a year, especially if you're the only source of income, before they get access to your accounts, if at all they do? As a normal adult, either in business or working, as long as you have a source of income, at any given point, you will have some money in the bank, M-Pesa, or in an asset, or maybe an investment somewhere. Most of this money or wealth ends up in the government's unclaimed financial assets accounts, simply because most of the time we all make a mistake of not clearly planning on what should happen in the event that we are not there. I know several people will feel confident about the fact that they already indicated a next of kin and sit pretty knowing that they have already addressed everything, only to realize that your next of kin might not even access any of your money. I posted this video on social media platforms that your next of kin is just an emergency contact person, and the reaction it received made me do this video to educate you and help you understand what really happens in the financial world, especially when the owner of the accounts is gone. In this video, I will explain to you what exactly happens when the owner of the account passes away, why your next of kin will not have any access to your money, and tell you who will access your wealth or money. I will also explain what the law of succession is, which is particularly responsible for what happens in this case scenario. I'll tell you if writing a will helps, how long does it take for them to access the money, how you can cushion or protect your beneficiary, and the worst case scenario of what could happen to your beneficiaries, with examples of what is already happening out here. Please stay with me to the end because you don't want to miss any of this. If you're new here or yet to subscribe, please press the subscribe button and join us as we create an easy environment where we can learn financial literacy and equip ourselves with knowledge to become better in our personal finances, investments, and in business. Don't forget to like and leave a comment or feedback in the comment section below. Let's get right into it. Whenever we open an account, maybe at the bank or an investment account, we are always asked to nominate a next of kin. And most of the time, we think so much about this person and end up settling on someone we feel deserves to benefit from the hard-earned money that I'm going to invest or deposit in my accounts, in case I am not there. What we don't know most of the time is that this person that we nominate as the next of kin might not necessarily be the one considered as the beneficiary. And in any case, this person will not access your account. They will not be given your money because in the financial world, you did not nominate a beneficiary, but instead what you nominated was an emergency contact person. Please note that the next kin is that person that the bank will contact whenever they can't reach you or in case of an emergency. This also applies during times when the bank can't reach you, even though you are not dead, but maybe for a very long time your account has been inactive and there's money in it and your phone number is not reachable. So every financial institution has been obligated to ensure that they only hold accounts of those who are active or alive, and anything that is not claimed over a period of time or acted upon should be submitted to the Unclaimed Financial Assets Authority. So when you spend a lot of time thinking if you should write your son, your spouse, your parents as the next of kin, you're probably worrying too much for no reason, if your thought is all about who will take the money or who will be given access to your account if you are not there. Instead, when choosing a next of kin, it's better to choose someone that you trust, who is available, and preferably an adult, because most of the time choosing a junior as your next of kin, and whenever there is an emergency and they need to reach you, it's going to be very difficult to find someone because the minor that you nominated cannot even be traced. To add on that, some institutions do not even allow you to have a minor as a next of kin. So what happens when someone dies and yet they had money in their accounts? By law, everything that you owned or was owned by the deceased becomes their estate. And for someone to access this deceased person's estate, they have to follow the due process laid down in the law of succession. This literally means that because I died, that does not mean that I stop becoming the owner of my property or my money. So whoever who needs to find access to this money, first of all, need to prove that they are the beneficiaries. And this can come in two ways, whereby you need to qualify as a direct beneficiary as outlined by the law, which in this case is the spouse, parents, brothers, sisters, children, especially in the case that there was no written or oral will by the deceased. The second way that you can be considered to have qualified as the beneficiary is when there was a written will or oral will. So does having a will help? By being the spouse or child or parent or family of the deceased, does it mean that you will automatically get access to the accounts of the deceased? And how long will it take for you to access this account or get access to the money? Before I answer this, let me take you through the law of succession and what usually happens from the moment information has been received that the client or the account holder is late. I am not a lawyer, so I'm not going to use the jargon included in law, but I'm going to give you an easy to understand guideline of what usually happens to our clients from day to day, from experience and from my personal research as well. The law of succession is what is used to guide the process by which the estate of the late, which includes the financial assets, the money, the shares, land, property, whatever it is that they owned, to be accessed by the beneficiaries or even distributed accordingly. This applies in several countries, although it may differ in one or two things, but particularly in Kenya, the applicable law in succession is the Law of Succession Act, Chapter 160, Laws of Kenya, and the Probate and Administration Rules, Cap 160. There are two instances whereby this law can be pursued. One is where there is a will, either written or oral, and this is known as or referred to as testate. And second is when there is no will written or there was a will but it has been invalidated, and this one is called intestate. Please note that even if there was a will written or spoken, it has to still be proved to be legit. There's also priority given when applying for grant or representation as the beneficiary, and this starts with the surviving spouse or spouses, then the other beneficiaries such as kids or family, then third, the public trustee, and finally the creditors or where the deceased had loans. Therefore, if you fall under any of these categories and you satisfy to apply, you can now go and make an application. The application will require information about the deceased, everything that they owned, your relationship to them, whether or not they left a valid will, and if they did, you will need to produce the original, and finally on any other matters that they may prescribe in court. Also good to note that even if you qualify to apply, an administration or grant will not be granted to a minor. It will also not be granted to a person of an unsound mind or someone that has been declared bankrupt. The application can also not be done by more than 4 persons who qualify to apply to become the beneficiaries. The application is usually done in the High Court. It is only filed at the magistrate courts if the estate value is below 300k. The requirements that should be filed at court include the death certificate, a letter from the chief or any authority confirming the beneficiaries of the deceased, evidence of ownership of assets or accounts such as title deeds, and written consent from any of the adult beneficiaries who chose not to apply for the same, especially when there was no written or oral will. You will also need to provide the original will if it was there, and all these will be filed together with the other forms usually called Forms P and A. There are some payments that are made which will take care of cost, especially the gazetting cost, and therefore once the payment has been done and all these other requirements have been lodged, they will be gazetted for 30 days to allow any aggrieved individual or person to object to them. And this is where the problem usually begins. But we will talk about that a little bit later. Whoever that feels entitled to this estate but was left out on the application that was already filed has the right to also file an objection to stop this process, or as usually referred in law as to stay the advertisements. We have both seen these court cases which keep lasting forever and ever, where people are fighting for entitlement for what belong to the late. But that's a story for another day. If no objections are filed after the 30 days notice, the letter of administration is given to that person who applied for it. But this does not mean that they have been given the account access. The letter of administration only serves as an authority for the administrator to administer the deceased estate, but it is not allowing them to distribute it. In short, they cannot withdraw the money or sell the assets. The only thing that you're allowed to do when you have the letter of administration is to manage and preserve. You can also be allowed to manage the properties, but you cannot do anything that can turn those properties into your own. When you have the letter of administration, you can now go back to the same court after 6 months from the date that they issued you with the letter of administration. And then you can go and file to get the confirmation of grant. Once you receive the confirmation of grant, from there you can now access the estate and even distribute it. So how long does it take to complete, and how can you cushion your beneficiary so that you are sure that your money will go to the right person that you had in mind? As I answer you that, there are a few things that you need to do now or be aware of, especially when it comes to going through this process. This process happens in courts, which means that there are expenses that will be incurred. And it's needless to say that some of those expenses that you will have to incur will include you visiting the courts and recruiting an advocate or getting an advocate or a law firm to help you go through the process. From experience and what others have gone through, of course, you can share your feedback as well in the comment section below. But what I've seen is that usually, by the time you present the case to a lawyer, they first go through the whole inventory of the deceased estates, which is the total value of everything that they own: land, assets, houses, money, shares, whatever it is. The unfortunate thing, though, is that most of the time, whenever the value seems to be big, I don't know whether this is because we are Africans or we were bewitched, but because in most cases this is very sad. The lawyers who are supposed to help majority of these cases, they end up turning against them and taking advantage of the situation at that particular point. They become greedy and charge rates based on the value they have seen on that particular paper. It's even worse if the person claiming or filing for the letter of administration is broke. The usual thing they say is, don't worry, we will write down every expense or cost. We will write all costs but by the time we access the account, you will pay me. In most of these cases, what you don't understand is that it might take forever to have these cases and all these processes come to an end. And by the time you are done, the bill that you're supposed to pay the lawyer is almost 70% or 50% of the value that you've been pursuing, my friend. We have seen situations whereby lawyers have had to pay school fees for the deceased, and I understand. And even in some instances, they end up having affairs with the spouses of the deceased in order to provide for them while they are going through this long process of succession. And this happens because your dependents, who are supposed to be your beneficiaries, are broke and they don't have access to your accounts or access to any liquid finances that they can use to sustain their lives. Since you left them, you were their only source of income and you didn't put measures for them to survive through that. Another worst case scenario is when someone who is more influential or has access to money claims entitlement. And because of their money and influence, they end up winning the case and end up becoming the beneficiary, causing you to lose what was meant for your true beneficiaries. The examples of worst case scenarios of what could happen can go on and on, but how do you cushion your beneficiaries from all this madness? First, if you can afford it, urgently go and get a life assurance cover and nominate your beneficiary. Let me quickly tell you why this. A pure life cover provides money in lump sum to your nominated beneficiary in the event of your death. This money will help them survive the loss of your income, number one, and also help them maneuver the succession process. When you have money, you can hire one lawyer to pursue your succession and another one to advise you to stay alert and know what to do at what point. Life assurance pays the beneficiary when the policy matures, which now in this case is upon death. If person X is the beneficiary, nobody else can claim it as well. This is the only way your dependent won't stay broke, waiting for the succession process to end. And as a side note, if you have assets and properties, get your quotation today because your case is even dire and you are playing with your beneficiaries' lives. The cover is cheaper in most cases than your TV subscription or your internet subscription, my friend. I'll leave a link below to help you request a quote today for consideration and for quick action. Next, have a clearly written will. Call it instructions if the name will scares you. Let the person meant to be the beneficiary have a copy, or someone you trust if your beneficiary is a minor. Although most people you trust are likely to disappoint, you can share the copy to your bank as well and a lawyer if you have one. Having a will makes the succession process a little bit easier. Notwithstanding, it can be challenged in court, but if you put effort to have it in the right hands, you will increase the chances of having a smooth succession. So yes, having a will helps a lot. And for the case of your preferred beneficiary being a minor, I would advise that you kind of split a small percentage of your money to an adult, most likely going to stay with your minor at that point, because a junior or a minor can't be given access until they turn 18. Not unless you're okay with them suffering till they turn 18 and waiting for the trustee to hand them their funds if they ever get traced. Anyway, as I wrap this up, how long till you access the money in the deceased accounts or estates? Well, these can't be said exactly because we have those which are smooth and very complex ones. But to be on the safe side, at least 9 months in a very smooth process. And this is because you will take between 1 to 3 months to get the death certificate and all the other documents required and the paperwork sorted out. And in the same time, you will be finding a lawyer who will help you with filing and going through the succession case altogether. Then you will have another like 30 days where the court will gazette the advertisement or rather your petition. And if you're lucky that nobody protests or stays the advertisement at this point, after the 30 days, you will be given the letter of administration, which still means you can't access the account not until 6 months after the date that you receive the letter of administration. That's why I have said that for the smoothest of the processes, it will take you at least 9 months to be able to access that account. Don't you think that you should plan on how your family or beneficiary will survive for that time till they get that access? Let me know if you have any questions or feedback, and please share with us your experience if you have gone through this personally or are currently going through the same process. Thank you so much again for watching. I believe that this video was helpful. And also remember to watch other educative videos in this wonderful channel.